Before my learned friends start, Lord, would your Lordship give us 10 minutes at the end just for a very quick, my Lord, clarification on 2 or 3 points that they've made?
Subject to when they finish.
Lordship.
Would your Lordship permit my friends to just adjust for 5 minutes?
Yes.
Milords, I second what all my learned seniors have argued on this side. Milords, I have 3 more points to state.
What is the good name?
Sorry, Milords?
Your name.
Kavya, my lord, Kavya Jawar.
Kavya.
Yes, my lord. I'll just pass the.
Pass on this one. Wait to now. Just pass.
Yes.
My lords, the very first point is that the Constitution of India has used the expression has been at 50 places, including Article 220, 233, my lords, which I have mentioned at Schedule 1 from pages 2 to 4. My lords, my submission is that has been means something which is continuing, and it cannot mean something that has happened in the past or at some point of time. Because, my lords, if that expression, if the meaning of has been would have been that, then the entire structure and for behind which the provisions have been brought into force would be frustrated, my lords. That articles I have mentioned from pages 2 to 4, my lords, 50 articles. Secondly, my lords, clause 1 of Article 233 has used the words appointment, posting, and promotion. My lords, my submission is that all the three words have to be juxtaposed and read together and not in isolation to give individual meaning to each of the said word. My lords, there is a reason why promotion and posting was not deleted even after there was a specific amendment moved in the CAD, my lords, and that should be taken into consideration, is my humble submission. Clause 1 deals with promotees and clause 2 deals with direct recruits, that too only for.
That's already been argued so many times.
Yes, my lord. And my lord, the third point is that clause 2 uses the word a person not already in service of the union or the state. My lords, had the constitution intended to include in service, it would have been explicitly mentioned. My lord, in schedule 2, which is at page 5, I have given a list of 15 provisions which by way of proviso or explanation have included the word include to mean something more when the constitution intended to. But my lords, when it is not used in Article 233, it has to be given a restricted meaning and not a wider interpretation, my lords. These are my submissions, my lords. Much obliged.
Thank you very much. Very well done.
There is another colleague of mine, which is assisting. Give your written submissions. Give your written submissions.
Your Lordship, in light of the
Let's proceed in.
Your Lordship, in light of the comprehensive submission which already my senior has made, I'll just confine my submission to 4 heads which I have already circulated. Firstly, the constitutional scheme and pivotal role of the High Court. Under Article 233 and 234, it's a self-contained code. Yes. And this principle has been very well recognized in the case of Mukund versus State of Bihar, which has very clearly said that well-knit and complete scheme, which is insulated from legislative or executive interference. When we say that, it shows that the High Court has the exclusive and a pivotal role to play. Secondly, there is a constitutional bar against any aggregation of experience. There is a categorical bar as to say, under Article 233(2), it has been stated that a person not already in the service of the union or of the state can be considered for direct recruitment only if they have been an advocate for not less than 7 years. That is immediately and continuously before the cutoff date. And when aggregating periods of past practices with judicial services is involved, in that sense, the plain text of 233(2) is violated. And secondly, the principle of exclusive recruitment streams also come into picture, which again gets violated. And thirdly, I would like to state that the constitutional design that candidates in service compete only through promotion can never be mixing with the direct recruits. Fourthly, I would like to conclude by saying that I am squarely covered by the principle of stare decisis.
That your senior has also very ably argued.
Yes, Your Lordship.
Also, the earlier 2 concepts.
Yes, Your Lordship. I'm grateful. Your Honor.
Thank you, very well done. We appreciate Mr. Ansari giving an opportunity to.
Here, Dr. Vivek Sharma also at some point of time, Lord, he should not go with a grimace, Lord, at the end, Lord, towards the. Nobody should go from the court without any grimace, not being heard.
Yes, yes, sure.
Pretty and encouragement.
We are happy for whom, Mrs. Shah.
Yes, may it please your lordships. My lords, I have the pleasure of appearing for the High Court of Madhya Pradesh in item number 501.6, my lords. 501.6. Lords, I wholeheartedly adopt, my lord, the submissions which have been made so far by my learned, my lords, friends on this side. And those submissions, if I may say so, with respect to your lordships, have been really very persuasive and throw some very serious thoughts about the, my lord, the understanding of the Constitution. So, my lords, I would adopt. At the same time, I am perplexed, my lord, what more can I really add to it, my lords? And when I have to mark my presence, my lord, but I have to speak few words.
With your rich experience.
I have to speak few words, my lord, so that your lordships. Now, my lords, the High Court has made a submission, my lord, it's on the already in the court. But I have prepared my own, my lord, 2 or 3 pages, my lord, we have tried to call out, my lord, the real questions which arise. If your lordships would please permit me, which not this one, supplementary submission. But they are styled as supplementary submissions, my lords.
There's one brief submission and one supplementary submission.
Yes, supplementary is, my lord, why? So that is in response to the, my lord's questions or the observations which have been arised.
Supplementary or the brief?
Supplementary, my lord. That would be better because then only I can adhere to my timeline also.
Yes.
Now, my lords, my first submission is this, my lord, that both the Constitution Bench judgments in Rameshwar Dayal and Chandra Mohan are not authority for the questions which have arisen for decision before this bench. Whether or not a sitting civil judge is entitled to seek direct recruitment as district judge never directly fell for consideration before the court in those cases. They have not even been directly or indirectly perceived as the questions arising for an authoritative pronouncement. A careful reading of both the judgments would show the decision turned out entirely on peculiar facts of those cases, rather than laying down any principle of law with respect to the questions framed herein. The passage of Rameshwar Dayal is being incorrectly read to argue that for in-service candidate no qualifications for direct recruitment are provided. Such observation in the judgment of Rameshwar Dayal is in respect to appointment under Article 233(1) and not 233(2). Article 233(1) deals with promotion as one source, whereas Article 232 deals with another source, which is direct recruitment from the bar. And for this reason, condition of eligibility under the Constitution has been provided. The submission that the absence of qualification observation in Rameshwar Dayal is only in respect of appointment within bracket by way of promotion bracket closed as district judge is further reiterated in Chandra Mohan case, and it has been categorically observed under Article 233(1) in the matter of appointment of district judge. The said article does not lay down any qualification for the candidates to be appointed or even denote the source from which recruitment is to be made. Therefore, the submission is that absence of qualification under the Constitution observation only pertains to appointment under Article 233(1) and not 2. However, it is submitted that as the requirement rules can be framed, recruitment rules can be framed, that is under Article 309 in consultation with the High Court, and have been framed in all these states. The qualifications for appointment under 233(1) by adopting the mode of direct recruitment and promotion are governed by the rules which are in force. In Rameshwar, all 5 were appointed by way of direct recruitment from the bar, and the question was whether they complied with the qualification under Article 233(2). 3 of them were actually practicing advocates at the time of appointment. In their regard, the question was whether their period of practice in Lahore could be considered. The other 2, Harman Singh and P.R. Sahni, did not have their names factually on the roll of advocates, which led to the argument that they were not eligible as per Article 233(2). The only point that fell for consideration was whether those 5 appointed district judges fulfilled the requirement of Article 233(2). The question has been answered by the court in two different parts and mostly on the facts appreciated in the light of historical background and the relevant rules. All 5 appointments were upheld as they were found to be practicing advocates, 3 actually and 2 notionally, my lord, that is Harbans Singh and Mr. Sahni. The question which the Honorable Court is considering whether in service incumbents are eligible to be considered for appointment directly as district judges never fell for consideration or was perceived in both the earlier Constitution bench cases. Chandra Mohan case only considered the meaning of service and interpreted it to be judicial service. For the first time, it arose directly for direct consideration in Satyanarayan Singh in 1985 and in subsequent decisions. In addition, it was considered threadbare by the Shetty Commission report, which submitted a lengthy report on this vital issue recommending amendment in the Constitution. The report of the Shetty Commission, which has been accepted by this Honorable Court repeatedly, itself recognizes that in order to enable in-service candidate to apply for direct appointment as district judge, constitutional amendment would be necessary inasmuch as the existing provisions of the Constitution do not provide for the same. It is respectfully submitted that without the constitutional amendment, in the garb of interpretation of the Constitution, a new provision cannot be enacted as it would amount to judicial legislation. It would be against the constitutional doctrine of separation of powers. Since the Constitution bench judgment is not direct authority on law as far as the question of allowing in service candidates to apply for direct recruitment as district judge, the only decisions which perceive this issue in a direct manner are the decisions in Satyanarayan Singh, Deepak Agrawal, and Dheeraj Bormelot, and Sushma Suri also. Satyanarayan Singh, read in the background of Rameshwar Dayal and Chandra Mohan, have held at the field. They have held the field for more than 40 years, and the requirement of the decision of state decisis
Stated this has been extensively argued by.
yes, should be. But I have a proposition, my lord. Yes. If a plausible view has been taken on the aforesaid decision, which cannot be said to be in direct constitutional violation of an express provision of the Constitution, this court should be slow in reconsidering overturning the settled position of law, merely because it is likely to bolster the career prospects of some ambitious in-service candidate is no ground for reconsideration of the judgments. My lords, the submission that I wish to make is this, my lords, which I have not articulated here. Your lordships are proceeding on the basis, as I have understood, my lord, that 233(2) does not provide for disqualification. There is no exclusion under 233(2) for the.
There is no quota card out for.
There is, yes. There is no, my lords, prohibition under 233(2), my lords, so for in-service candidates. But, my lord, that may not be with greatest respect a right understanding because of the words used, my lord, in the same, my lord, sub-article has been. The real problem, my lord, for the other, my friends, my lord, on that side is not, my lord, Dheeraj more. The real problem, as I understand, is, my lord, the interpretation placed upon the words has been, my lord, in Deepak Agrawal's case, which is a bench of 3 judges. If has been interpretation of the meaning which has been assigned by decision of this court, to which, my lord, no fault has been found so far, which means, my lord, has been means present past continuous. That means as advocate, he must be practicing on the date of the application, my lords. If I may just place that judgment of Deepak Agarwal, or your lordships may only note the paragraph, para 102, my lords, which is of the judgment, which is para 88, 88 in your lordships volume, my lord, page 744. Volume 5.2. Lord, may not open it, Lord, but allow me to only read it, how they have, Lords, articulated this part. The Lordships have said, as regards construction of expression, if he has been for not less than 7 years or an advocate, in Article 233(2) of the Constitution, we think Mr. Prashant Bhushan was right in his submission that this expression means 7 years as an advocate immediately preceding the application and not 7 years at any time in the past. This is clear by the use of word has been. The present perfect continuous tense is used for a position which began at some time in the past and is still continuing. Therefore, one of the essential requirements articulated by the above expression in Article 233(2) is that such person must, with requisite period of continuing as an advocate on the date of application. So this is about the prohibition. The word has been is the prohibition. And colors, it flows from here. The other part of the submission, which I was wondering myself,
Which is the paragraph that you read from Deepak?
this is para 88 in Deepak Agrawal in your Lordship's volume 5.2 at page 744. My lords, a judgment by a bench of 3 judges, my lord, learned judges. That's my lord. So if this word has been, has this meaning, my lords, that he must be a practicing advocate on the date of the application, then, my lord, the prohibition creeps in, that it comes in. It has to be read in, and it has been so read. Then they are not entitled, my lord, to apply. The second thing, my lord, I was wondering as to why in the article scheme of Article 233, there was 1 and 2, two different expressions have been used, my lord, so far as the role of the High Court is concerned, my lords. In first part, it is consultation is, my lord, the word used in consultation with the High Court. The governor is the appointing authority, that's a general declaration. Is the appointing authority in regard to the appointment to be posting and promotion of district judges. How that has to be done is in consultation. Whereas in contrast, your lordships will notice in sub-article 2, my lord, the word recommended by the High Court has been used. My lord, I was trying to, my lord, find in my own humble way, my lord, a meaning to this, and my submission is this. And that's an indicator, my lord, that the promotion will take place under sub-article 1 only. Promotion will take. Why? Consultation is a word, my lords, of a lesser import, of a lesser, my lords, strength, as compared to recommendation. Consultation may be binding, may not be binding, but my lords, in the case of High Courts, your lordships have always said that it is binding. I assume that it is binding. But it remains consultation when the Constitution was framed. Why? Because my lord, all the incumbents who are in service, they are within the control of the High Court, under the control of the High Court, 235. Their service records, everything is available. The High Court knows who is what. Their services, my lords, every particulars are available. So, my lord, a word of minor, my lord's import, that is consultation, is used. My lord, that is indicative of the fact that 2 promotions will take, my lords, only, my lord, in the stream under Article 233(1). Whereas, my lord, when in contrast, the word recommendation has been used in Article 2 by the High Court, that means, my lord, recommendation has some persuasive, my lord, some authoritative, my lord, push behind my lord's recommendation. Is a stronger expression than consultation. Recommended.
Are different.
Yes.
It's only for, you can just loosely call it as.
No, the words are not wasted by the Constitution makers, Lord. We will assume that they made the choice of the words carefully.
No,
But when my lord, the words recommended is used, that means a person is being recruited from outside. The High Court does not know only through the, my lord, the selection process. So it is in that context, my lord, the word recommended has been. So, my lord, that may be one indication, my lord, with regard to this. Now, my submission, my lord, is this. Ever since the Constitution has come into force, number of decisions have taken place, and this position of law has been settled. On that basis, my lord,
That is everybody's argument.
Your argument is.
I'm trying to say something, my lord, and I know that.
Sir, your argument is contrary to what C.U. Singh and said and others.
Not at all, not in the
Tell you
least,
why.
my lord.
Let me tell you why. If you say Rameshwar Dayal and then Chandramohan do not lay down the law.
I do not say that.
But do not say.
No,
They are dealing with some other issue. The fact.
I'll show that now.
We'll tell you why. The fact remains, at least till the decision in Chandramohan, and even thereafter, till,
I
till,
saw, my lord, something
till
very
this
interesting.
subsequent judgment
Lord,
in Satyanarayana has
I'm just not
come into
sure,
being.
Your lordship, my lord, something.
We just tell you on the status, on principle statuses, it was not there from day one onwards.
Sorry.
See, from day one onwards, right from 1938 Act and also after the Constitution, it is not as if lawyers alone were allowed to compete in the direct recruitment. It is not that.
I'm not.
The origin, we tell you because on the principle of statistics, you are saying that what is settled should not be unsettled. That principle will not apply for more than one reason because originally they both of them were allowed. It is only after the judgment of this court only that the problem came.
Dheeraj Moore, your lordship.
That's correct. There is more even you include Satyanarayana Prasad. Therefore,
National
My lord, I believe, my lord, 1985 onwards, when Satyanarayan Singh authoritatively
therefore
said,
it's not as if it has been there.
Satyanarayan Singh in 1985
yes.
turned down this argument, my lord, formally by saying that the in-service candidates can also apply for direct recruitment under 233(2). I don't think, my lord, ever anybody would have flouted this law of this land, my lords, after 1985. I'm not, my lords, I don't have the statistics and the facts, but in 1985, this is Channappa Reddy, my lord, said that they may not, that cannot be permitted in UP case to compete.
Right, at least till then.
Yes.
Till then the scenario was different.
So 1985 is 40 years, my lords.
It's not from the beginning.
My lords, why I'm saying, my lord, that the question did not arise in, my lord, the question which your lordships are grappling with today did not arise either in Ramdayal or Chandramohan is, my lords. Please have my lord Chandramohan for a moment.
Then the principle of stare decisis can be applied when the law is expected to apply for a larger section of society. It is not meant for deciding a issue like this. What is in vogue to be applicable to every citizen. If you change it, it will create some
Exactly, my
hardcore
lord,
or
yes.
something.
So
It's not that, it is only
that
mere.
that is my lord, that's the principle which state
Yes.
decides this. But also note from Chandramohan, my lords, your lordship will please see from Chandramohan, my lords, that this question was raised in the judgment. Give me that. Page 82, my lords, internal page 82,
Yes.
but not answered. My lord, if your lordship will see the lordship's reference. Page 185 of my lords, the Chandramohan, kindly note that. Page 185,
Yes.
volume 5.1,
Yes.
185. Well, Lord, the
Page?
page, my lord, 185. That's, I'm referring to Chandramohan's case.
Yes.
Your lordships will notice the paragraph beginning with the sentence, the arguments of the learned counsel for the appellants may be placed conveniently under the following 5 heads. Then please come, my lord, between the placitum E and F. The head number 4. I hope your lordships,
Yes, the governor has no power.
yes. Head number 4 is the question number 4. The exclusion of the members of the judicial service in the matter of direct recruitment offense, Article 14 and 16 of the Constitution. Well, Lord, this was question number 4. The lordship stopped at question number 3, did not answer question number 4. Because in question number 3, the lordship's answer was that service, my lords, in the context of 233(2) means judicial service, and that is where the judgment stops. It does not answer, it does not consider the question which was raised in this judgment. That is why I'm saying, my lord, that these are not the judgments for the authority, for the proposition.
We don't want to interfere, interfere when you are arguing, all of you are arguing. The Chandramohan itself premised on the footing.
My lord, if this question was,
Listen to us. Repeatedly we are telling, see, when it's suppose in the case of promotion, there's no need to interpret what is your union, what is service under union, what is service under state. Because once you have a structure, once you have a system for promotion, it takes care of it. It is only when direct recruitment came that the interpretation required. Whether any service under the state or central would come under the eligible direct recruitment.
but with,
That's the problem. That's what we have been repeatedly telling.
but with,
Chandramohan proceed, he was only concerned with a direct recruitment. It does not concern itself, Rule 14 is also the same. It does not concern itself with a promotion because nobody is concerned with the promotion. no challenge would have come.
So,
Challenge itself, that is why they gave the interpretation. Because they understood that a service, somebody's service candidate is also eligible under the direct recruitment. Now, unfortunately, 1985, as you rightly said, that's where the issue, the other issue is started now.
so they
Otherwise, everybody's understood that way. Because when judgment has come, it has taken a different turn thereof.
Therefore, my lord, perhaps I'm right. With great respect, my lord, to your lordship, my lord, I'm right in saying that even though the question was raised directly, my lord, in Chandramohan, it was not discussed, decided, my lord, and answered.
Very good.
Whether in-service candidates are entitled, my lord, to apply for direct recruitment. And therefore, my lord, your lordships may independently, my lord, interpret the constitution.
Yes, yes.
But so far as the question, my lords, which have been framed, my lords, are concerned, your lordships can take some assistance, my lord, from the observations made herein, but they are not, my lords, conclusive, those observations. Your lordships have always said, my lord, that a judgment is an authority for what it decides. Every observation, my lord, of the reasoning that is contained is not binding. What is binding is the ratio.
What we are trying
The
to get
ratio,
is that.
lords, please permit me, my lord, to complete.
All right.
My lords, what Chandramohan, my lord, holds it, my lord, the ratio, if I can say, of the Chandramohan is that service means judicial service, nothing else. That's the only ratio. That's the only law declared in Chandramohan. Yes, my lords.
We consider that.
And the second thing, my lords, which has been quite, my lords, been impressing your lordships' mind, my lords, is that if a Tahsildar can compete for IAS or IPS or, my lords, a teacher or, my lord, a constable or some inspector, why not? My lord, they. The reason is this, my lord, there is no comparable analogy. Why? Because appointment of, my lord, district judge is governed by Article 233 of the Constitution in a particular way and manner. Appointment with the my lords, to IAS and IPS and other services are governed by rules made under Article 309. They are not constitutional appointment. They are not governed by constitutional provisions. They are governed by the rules. So, my lord, that analogy may not be applied, my lords, and I think is not correct. My lords, all the conditions of recruitment, service conditions, everything is prescribed under Article 309 by framing rules. Either the rules are framed by the president or by the governor. President in respect of the union service, governor in respect of the state services. So that may not be the correct, my lords, approach. My lords, for all the other matters, my lords, I adopt the submissions, my lords. And I must say, I must compliment my lord that they have batted very well. And as a last batsman, my lords,
It's always
as a last
right.
batsman, I was not really expected to do much, and particularly, my lord, on a pitch. My lord, by playing on a pitch where the balls are bouncing so, my lord, fiercely.
In such
Always
cases,
it's more difficult
he also, in such cases, what happens if 5 runs required, 1 ball, he will hit a 6.
It happened, my lord, in the India-Pakistan match.
Kapil Dev.
Well, India-Pakistan match, that player who became captain, my lord, Pakistan. Javed, he hit my lord in the last ball is 6, and Pakistan won a World Cup match. Anyway, my lord, I'm not that person. I'm not that. I have no qualms about my ability, my lord. So this is all as High Court I have submitted, my lords, and we have framed our rules, my lord. We are following the rules, my lords, and those rules are not in question. Grateful.
The lighter vein, my lord, Mr. Shrivastava has declared the inning. He said he's the last man. I'm sorry, my lord.
Last but one. My lord. Last
Just
but
in a
one.
lighter. In a lighter way.
Last but one.
My lord, I know.
We'll reframe this as tailenders.
We will hit a 6, my lord.
No. With my lords, Justice Sundaresh being there, helming the cricket team, I know this is impossible. He's not only a good bowler, but a good batsman as well. So he knows how to defend and bowl googlies. Now, my lord, I know your lordships are exhausted. Most of the ground has been covered. But since it's my duty to present what I am being instructed to,
You are appearing for whom?
my lord, I appear for in 501.8 direct recruits in review petition for respondent numbers 3, 5, and 9. My lord, in keeping in mind the time that my lords have allotted, and I don't want to.
We are not allotted. That has been allotted amongst yourself by all of you.
Lord, with your lordship's directions, we had to comply with it. My lord. And you have given it to the other side. In fact, my lord, there is a Greek character called Sisyphus. Today, respondents called Sisyphus, my lord. My lord, I the respondents presently, my lord, because of the observations field, he was punished by the gods to roll a stone up the hill, my lord. Every time he rolled, it came down. So I don't know where we are going. But please, my lord, can I just draw my attention to the written submissions that I have made, my lord? Just to
All written submissions should have been part of the compilation because
Lord,
now.
Lord, I made it a little shorter so that what I'm going to, instead of Lord making a oral submission to a large extent, I just wanted to quickly run your lordships through this. And if necessary, I'll say whatever has to be said, my lord. My lord, according to me, there are three categories that your seniors, that your lordships have to deal with. First, those who have practiced as advocates for 7 years or more prior to entering judicial service. Second, those who have practiced as advocates for less than 7 years prior to entering service but covered the remaining period stipulated in Article 332, 233, Clause 2 with their experience in judicial service. Third, those who have not practiced at all as advocates but have been in judicial service for 7 years or more. These are the three categories broadly that your lordships have to deal with. Now, insofar as the second and the third category that I have listed out, my lord, is concerned, it is my submission, my lord, it's our respectful submission, that those judicial officers who have less than 7 years as advocates but cover up the deficit with their experience as judicial officers or have not at all practiced as advocates and rely entirely upon their experience as judicial officers are clearly hit by Clause 2 of Article 233. Upon a plain reading of Clause 2 of Article 233, what emerges is that for a person to be eligible for appointment through direct recruitment route, he or she has to cross the following hoops. First, my lord, and that is what, as I read subclause 2 or clause 2 of Article 233, he or she should not be in service of union or state, which is now settled and should be read as judicial service. That is what has been held in Chandramohan. The person is an advocate or pleader, and the person concerned should have practice for not less than 7 years. So unless, my lord, insofar as category 2 and 3 is concerned, it is our respectful submission, my lord, there clearly one of the other condition is not fulfilled. Therefore, my lord, that's para 3. If a person is in judicial service, he or she is not eligible to take recourse to direct recruitment route, since such person shall fall on account of her ineligibility. Thus, logically, even if she or he were to clear the exam and interview, such person cannot be recommended for appointment as a district judge by the High Court. The judgment, my lord, we rely upon Satyanarayan for whatever it is worth. Your lordships have expressed a view, my lord, brings out this aspect quite clearly. As far as persons in judicial service are concerned, they can be appointed through promotion route, both by applying one of the two yardsticks, which is well known, my lord. Merit comes seniority or pure merit. The pure merit yardstick is available to those who take limited departmental competitive exam. Their appointment is made by the governor of the concerned state in consultation with the High Court. The qualifications are provided in the recruitment routes. The argument of the petitioners that permitting in-service judges to compete in direct recruitment quota, which up until now is available to advocates, because it would incentivize the talented ones amongst those who are in service by opening up more avenues, loses, according to us, sight of the following. Lord, even today, a large chunk of posts, i.e. 75%, are available to in-service candidates, both through promotion and LDCE. Infusion of advocates at district judge level via direct recruitment aligns with the plain language of Clause 2 of Article 233. The submission propounded by the petitioners, although attractive at first blush, would lead to anxiety and disruption of career paths amongst those who are in service. For instance, my lord, this is an example that your lordship would like to at least examine.
But then that would also happen in LDC, LCD.
Yes.
If,
so, my lord,
if a junior person gets selected as a district judge over his senior, then that anxiety would also affect in such a case also. So then the LCD also has to go.
My lord, so therefore, my lord, the argument is this. My lord, the argument is this. I appreciate what has fallen from my lord. If you have the LDCE route, then you can upend someone's career by going through that route. But those two routes are available to them for in-service, as against those who are not in service. So, my lord, the concern... I'm so
there
sorry.
also there's an embargo. Now we have provided some quota for division, senior division also. Earlier, they had to complete 7 years of practice for appearing, I think earlier it was 10 years, we have brought it down to 7 years now.
Yes, my lord, I am relying upon my lordship's judgment. In fact, one of my arguments in this submission that I've placed before my lords is that your lordships in the 2025 judgment, which is the fifth AIJ case, my lord, your lordships dealt with this aspect. Your lordship will remember that the LDCE quota was brought down to 10%.
From 25 to 10.
From 25 to 10. Your lordships said to incentivize, we need to increase it 25%. So a sort of impact assessment was done. So it is not as if, my lord, they don't have enough opportunities. What this court is being asked to do by the petitioners is open a third avenue, which according to us is a disruptor for two reasons, my lord. Your lordship may ultimately agree or not, which is that your lordships are called upon to, in a sense, read into clause 2 what is not given there plainly. 1. 2, my lord, it is our submission that this will cause disruption. The example that I gave, your lordships give a counter example, that is, my lord, obvious that as between those who go through the promotion route, seniority, merit comes seniority, and as against those who go through only pure merit, there is that race. But now you are also giving them an opportunity to get into direct recruitment. Apart from the fact that your lordships in the 2025 judgment, the fifth AIJ case, has increased the LDCE quota. B, your lordships have also said why experience even at entry level is important, that you should be an advocate. Now, please try and appreciate, my lord. And this is what I've said later on, my lord. At every level, your lordships have, or the constitutional scheme is such that advocates are appointed. Not the district level, because of Article 233, Clause 2. At the High Court level, the ratio is actually 2/3, 1/3. And then, of course, the Supreme Court, with a special dispensation under Article 124, that you can also appoint a jurist.
Why? So advocates are better than judges who are functioning at the district judiciary.
My lord, I am not making a comparison. But, no, my lord, I am.
It's like saying,
sorry, my lord, your lordship.
A is better than B unless you give the opportunity. That is exactly what we are saying. The idea is to empower the institution. Once you empower the institution, things might change. Yeah, to have the quality at the bottom is what we are saying.
My lord, please, can I know, my lord, what's going through my lord's mind. My lord, can I just say, when it was reduced from 25% to 10%, the experience was not good.
It's not a.
I'm just saying, my lord, it is not as if there were not enough opportunities, or there are not enough opportunities.
On the structure, basic structure. See, now, judging it is more like it's a calling.
Yes.
Departmental thing, you just go in employment and you see, consider interest, seniority, I should come, you should come. It's not that. We are not, for a moment, we are seeing the parties, we are not seeing the parties. We are only seeing about the constitutional mandate. See how the forefathers of the constitution thought about it. How to make sure that institution stays vibrant, which is at the bottom. The faith of the institution depends upon the functioning of the district judiciary. For that, you have to infuse more quality. More quality will come and more competition. So obvious, in the absence of any restriction of the constitution, we can't do it.
Lord,
we understand that you might lose out something.
My lord, we understand what is falling from my lords, my lord. But coming to para 8 of my submission, my lord, I want to refer to the Honorable Chief Justice's judgment, where your lordships have said what experience means of advocates, my lord. These paragraphs, I don't want to read it. Justice Chandran was also party to that judgment along with Justice Masi, my lord. Where your lordships have said why advocates are important in the system. Now, this has been the preserve of the advocates for a very long time. What your lordships are asked, my lord, your lordship said it was not there before 85, but 85 to now is a long period. With your lordship's judgment, increasing the quota for LDCE, it is our respectful submission, my lord, that your lordship should allow it to play out so that.
You just consider a situation.
Yes, my lord.
Even for LDC, he has required to, earlier the requirement was 7 years, 10 years. Now by this judgment, you have brought it down to 7 years.
Please.
Suppose if a candidate is at the bar for 5 years, he will be entitled to appear for LDC only after he completes 12 years. And whereas
yes,
a person from the bar would be entitled to compete against this 25% post immediately after completion of 7 years.
Lord, can I share an experience which, can I just, 35. But can I share an experience, my Lord, which I'm sure, my Lord, your lordships have far more experience.
35.
Actually, senior division, it takes 5 years and then 3 years. So in cumulatively it comes 8 years for LDC.
No, we have made it 7 years.
MP, I could lose 5 years.
I'm talking about the judgment.
No, your lordships have made it 7, which includes a period as civil judge junior division. But
So,
my
junior
Lord,
division and
my Lord, the experience is this. Even when we had this quota for LDC, my Lord, we actually didn't get enough people. And which is why, my Lord, it was reduced to 10. There is, I'm so sorry, Chief Justices. May I just respond, my Lord? This is an experience which all of you have, my Lord, and some of us on this side also have, my Lord. When we tried to fill, because what happens is, my Lord, when you're in service, somehow after some,
Yes.
sorry, my Lord.
You have a lot of experience also sitting on the committee.
Hey, yeah, NCMS committee, my Lord.
No, even that LCD committee.
Yes, my Lord, can I, your Lordships are right, my Lord. In fact, that report should be, your Lordship should make it public at some time whenever your Lordship thinks it's necessary. But our experience as, and if your Lordship pardon me to get into that area is, if I get into that area is when we asked for in-service candidates, how many of you want to sit for the LCDE quota, my Lord? They didn't, because once you're in service, you are very cagey about taking an examination.
That situation in Delhi was, it's a very peculiar situation. I have considered in my judgment,
Yes, your Lord.
sitting with Justice Rageshwar Rao.
Your
Because by the time one became eligible to appear for LCD, he was already eligible to become through routine post. And therefore, initially we reduced the 10 years here, 10 years requirement to 7 years insofar as Delhi is concerned. And subsequently in that judgment, we applied it to all India, pan India basis.
No, that was one set of circumstances, with your Lordships pointed out, my Lord.
Yes.
Delhi had that particular, but your Lordships have noticed in your own judgment.
No, that is another judgment. That is 3 judges. I am talking about a judgment which was rendered by me when sitting with Justice Rageshwar Rao. When we found that in Delhi, by the time you are eligible to appear for LCD,
Yes.
one is already entitled to be promoted through the regular channel, and therefore there is no incentive.
Your Lordships are right. But
That's the
from your,
position that happened with most of my clients. By the time they were eligible to sit in LDC, they were already eligible under the promotion thing.
They'll be 40, 45, they'll be just doing it. So one
Therefore,
small
we
incentive.
brought down that 10 years requirement to 7 years.
my Lord, your Lordships just turn to volume 5, 1150 of your Lordship's judgment for a moment. Paragraph 18, my Lord.
Volume 5.
Volume 5.5.3, where your Lordship's judgment, 1150, it starts at 1150, running page, and it is at 1160. I know, but I'm referring to this. Where your Lordships, my Lord, while dealing with this business of increasing the quota, noted this in paragraph 18. My Lords, the Honorable Chief Justice, just have a look at it. And today, my Lord, with respect, the petitioners have not given you any empirical data, my Lord.
Rajiv, what is the total number of judicial officers in Delhi?
Lord, in Delhi, there would be about, I don't have the current figure, but I can.
Approximately.
Lord, there would be about 6. Is 500 something.
The internet is showing 60.
Yeah.
You wanted to clarify.
I will give you the.
More than 100?
Yes, my Lord.
All put together.
Yes. No, it's more than, much more than 100. It's actually 700 additional district judges.
700?
Yes, my Lord. And 350 metropolitan magistrates across districts, my Lord. So it's a city state.
The reason why my brother is asking the question is this.
Yes, my Lord.
In that direct recruitment,
Sorry, my Lord.
that direct recruitment post for the district judge,
Yes, my Lord.
in every state they'll be eligible among the district judiciary will be 100 or 150. where lawyers will be applying 2,000, 2,000 or 3,000. What is a big deal that's going to happen to you? This is what my brothers want to say. Nothing much.
change.
You have 35 years minimum, then there will qualification. There is a similar symbolic way. There will be about 150 people. Why you feel shy of competing with them in the open category? Is what is my brother is saying. You see, nothing but apprehension, nothing else. We'll tell you why. You also would have seen it. Most of the cases, we in the director court, we are not able to fill it up. At least now, someone else will be qualified will come. Let us take it for example, for statistics, if you take through the country, in every high court, every year selection for district judges, director court, if you have 15 vacancies, only 5 would be able to be filled up. It is not that they are going to be standing in competition for you.
My lord, on the same note, can I just show this, my lord? Paragraph 18 of my lord's judgment, my lord, where your lordships noted the position of some of the high courts. My lord, in the middle, paragraph 18, where your lordship said, my lord, the Chief Justice has it.
Yes.
Some of the states also face difficulty that sufficient number of candidates were not available for being promoted under the, does my Lord Justice Sundaresh have it?
Yes. Paragraph 18, is it?
Yes, ma'am. 1160, my lord.
Yes.
In the middle, some of the states, does my lord have that?
Yes.
Also face the difficulty that sufficient number of candidates were not available for being promoted under the LDCE category from the cadre of civil judge senior division. So the point that I'm making is, my lord,
No, that was why the 25% quota was reduced to 10%. And thereafter we had elaborately called for the responses from all the state governments, high courts, and thereafter we found that now there was a sufficient feeder strength to compete for 25% LCD quota, and therefore we increased it to 25.
No, and therefore, my lord, in paragraph 20, the next page, your lordship said, since with the passage of time, does my lord have that?
Yes,
Honorable Chief Justice. Since the passage with the passage of time, sufficient number of candidates in the cadre of civil judge senior division were eligible to be promoted as district judge through LD. Certain IAs were filed before this court for restoring the set quota from 10% to 25%. So my lord, it is the experiences that the court has on the administrative.
That
My lord, when it got
such cases that make the law.
Now, I can only say, my lord, when it got reduced, the experience was that you were not getting enough candidates. Today, without any empirical data, my lord, your lordships are being called upon to interpret Article 233 in a manner which, my lord, to us, it's our contention again, my lord, that with respect, that it is going to be a disruptor, my lord, even amongst those who are in service stream, my lord. Last but not the least, my lord, the two judgments, Rameshwar Dayal and Chandra Mohan, my lord, according to me, were on two peculiar facts. Ramesh Dayal dealt with a situation, Rameshwar, my lord, dealt with a situation where advocates who had been enrolled with the Lahore High Court, my lord, whether they did they continue to
There were
be
two
on the rolls?
conditions, two eventualities. One, 3 of them, high courts enrolled in Lahore, whether their experience could be taken into consideration while computing the years of practice at Delhi, and 2 of them were in service. Mr. Sawhney and Mr.
No, Lord, they were also on the rolls. That's what was shown to you, my lords, yesterday, my lord. Even Sawhney and Harbans. So they continued to remain as advocates. So
That is
the distinguishing factor that the petitioners tried to.
We'll consider
Sorry,
that
Lord.
deemed continuation. That's just, they were deemed to be on the role of the bar.
Yes, and therefore, my lord, that is not an authority for the proposition that the petitioners are putting forth. Why? It was a peculiar circumstance.
That is also not an authority to say that the in-service candidates cannot compete in that bar quota.
I'm not saying so, my lord. This is my respectful submission, my lord. I'm not saying Rameshwar Dayal. There are some observations which both sides used and which was noticed in Dheeraj. My lord, would your lordship see the observations in 9.1 which I have extracted from Rameshwar Dayal? My lord? Would my lord just see in the written submissions? Why did the court feel compelled to pass the judgment that it did? Constitution by 9.1, my lord. the peculiar circumstances. What will be the result of interpretation canvassed for and on behalf of the appellant if it is accepted? Then for 7 years, beginning from 15th August 1947, no member of the bar of the Punjab High Court would be eligible for appointment as district judge as a result, which has only to be stated to demonstrate the weakness of the argument. So they said they will continue, and they continued on the rules, and that was a peculiar circumstance. Now, Lord Chandramohan also, according to me, only dealt with what does in service mean, and they came to the conclusion it is judicial service, Lord. And Lord, rest, of course. Lord, one aspect that I want to draw my Lord's attention, Lord, and I end with that. Lord, there was reference to Constituent Assembly debates on behalf of the petitioners, my Lord. If your Lordship see paragraph 12 of my written submissions, my Lord, it's more than well settled in State Bank of Travancore, and this is cited in Keshavananda Bharati, that you cannot, it's not a good external aid for understanding the provisions of the.
Your side also.
Sorry.
On the some of the councils on your side also refer to the Constituent Assembly debates.
My Lord,
Contend that it was only meant to be a bar.
no, it may be so, my Lord. We are all trying to assist my Lords, my Lord, but this is based on the judgment of 5 judges of this court, which is followed in Keshavananda Bharati. My Lord, the reason is very simple. They say when you get up in the Constituent Assembly or whoever made the speech, there are others who have not. So you don't know whether they are aligned. Drafting committee report, my Lord, is something that you can use as an external aid, not the debates in the Constituent Assembly. It is more than once well settled. I am grateful, my Lord.
Thank you. Thank you.
Your Lordship's patience.
As I can say, Malos, I start the middle order or maybe the tail end on behalf of the respondents on this side, Malos. I appear in Malos 501.15. Malos, that's the matter Dheeraj Moore versus High Court of Delhi. I represent the Delhi High Court.
You appear for Delhi High Court?
I appear for the Delhi High Court, Malos. Malos, most of the submissions which we had jotted down, Malos, have already been covered, but just for convenience, Malos, so that I can straight away, Malos, tick off. Easy. There are 1 or 2 things, Malos, which I would want to highlight, Malos, which I feel have not yet been covered. Malos, I'll skip 1 and 2 for the meanwhile, Malos. And Malos, I'll come to serial number 3, Malos, because that's been the discussion so far. Rameshwar Dayal and Chandramohan. Malos, it has been, Malos, on this side, Malos, it's been argued that insofar as Rameshwar Dayal is concerned, Malos, it's very clear, Malos, that the ultimate, Malos, the factor, Malos, on the basis of which, Malos, the relief was granted, was the fact that the petitioners continued to be advocates on.
That has been argued too.
Yes, Malos. So, Malos, that's the reason, Malos, only in one sentence, Malos. And likewise, Malos, in Chandramohan, the, Malos, the opening phrase has been interpreted to be judicial service. So, Malos, what would be the connotation, Malos, of the fact that Article 233(2), when, Malos, the word service is used as judicial service, because that provides an absolute bar in our submission, Malos. Malos, because, Malos, has been advocate 7 years, comes subsequently. Malos, 233(2) starts with, Malos, with a bar, Malos, of anyone in the service. And in case that service is interpreted as it's been interpreted, Malos, in Chandramohan, that it is a judicial, that it is, Malos, and again, even though the issue, Malos, was so far as judicial officers are concerned, it does say that it's a euphemism. But what has been interpreted is the clause Article 233(2) and the word service. In light of, Malos, how the chapter flows. So, Malos, if 233(2) is service, is judicial service, Malos, then the rest of the part, Malos, does not come into picture. That's my submission, Malos. Now, Malos, and Lordship may see, Malos,
what is your submission?
Malos, would Lordship kindly have, Malos, 233(2). Malos, when it says, Malos.
You've it down so many times, you can read.
Yes, Malos. Malos, just for my benefit, Malos, it says a person not already in the service of the union. Now, Malos, when it's read as service is read as judicial service, it means a person not in judicial service. So, Malos, that's, Malos, where the first, Malos, hurdle has to be crossed. That someone who's either in service or not in service. If,
according to you, a person who is in service. He's not entitled under
in
property.
judicial service, my lords, and the reason why, my lords,
So a person who is in some other service is entitled.
my lords, that is, my lords, on the basis of the Constituent Assembly debates, my lords, that's how, my lords, my lords, Chandra Mohan turns. Because under, if, my lords, 233(1),
Whatever new you want to argue, you may argue, yes.
my lords, I'm saying, my lords, in terms of Chandra Mohan, 233(2) creates a bar on anyone who's in judicial service because the word service is being interpreted as judicial service. What has been the
You are doing total violence to Chandramohan.
Malus, may I just, Malus, page 194, if Lordship may have, Malus, volume, Malus, volume 5.1, Malus, would Lordship just, Malus, it's specifically, Malus, it's a word which is used, Malus, that service is judicial service. Page 194, top, Malus, would Lordship just note that. Malus, what has been the subsequent follow-up of that? Malus, Malus, it's been argued that it's a, Malus, a stay decisis. Subsequent to that, Malus, there is no judgment of your Lordships whereby any judicial officer has been permitted to apply under Article 233(2). It was only, my lords, in Satyanarayan Singh which was rejected. The others which have been allowed were all, my lords, advocates as on date. So, my lords, Shushma Suri, Deepak Agarwal, they all dealt, my lords, with those candidates who were appearing as prosecutors, who were actually appearing in the court as lawyers. Even in the two bench judgments, my lords, which have been relied upon, which is Vijay Kumar Mishra, my lords, and Sunil Kumar Verma, which has been Chief Justice Lordship. Para 4.3, as on the date when they applied, they were lawyers with 7 years of service. It is only the hiatus by the time when they were recommended, between the time they were recommended and they ultimately came to be appointed, they joined some other judicial service, lower judicial service. So, my lords, my submission is there is no judgment so far interpreting this this article, my lords, which provides.
Therefore, we should not deliver a judgment.
My lords, it is, my lords, the other way around. My lords, if the provision has been interpreted and as construed in a particular way, my lords, that's a submission.
That Keshavanand Bharati ought not to have come. Why should?
My lords, I'll come to that. My lords, if Lordship might have para 5, my lords. Subsequent to 66, my lords, and Lordship may just permit me to make.
Shankari Prasad was appealed in Sajjan Singh. Sajjan Singh was upset in Golaknath. Golaknath was again reversed in Keshavanand Bharati.
My lords, Lordship are correct, my lords.
So law has to be static.
My lords, insofar as the interpretation which does not provide for any other alternative. It's a submission, my lords, that now, my lords, Lordship have para 5, my lords. Subsequent to 66, my lords, judgment, there have been 3 constitutional amendments. My lords, there was, my lords, amendment right immediately after, my lords, which is the 20th amendment. And, my lords, article, my lords, 233A was introduced, validating all those, my lords, appointments which had taken place, but were held to be illegal by your Lordships. My lords, there was no amendment to the Article 233 per se. It only validated, my lords, those appointments. Subsequently, my lords, with reference to 217, again, my lords, there have been 2 amendments which allows, my lords, the experience of a judicial officer to be, a lawyer can count his experience as a judicial officer and vice versa. But there's been no amendment, my lords, to this section, this article. And that's how, my lords, it's come to be understood. My lords, as also referred to Shetty Commission, my lords, that's been referred to. Shetty Commission itself says that the Constitution does not provide. So, my lords, that Lordship may just note, my lords, in 6.2.
Already provided.
Yes, my lords. My lords, there was a query, my lords, which in the morning Lordship had raised, my lords, and which had raised right now, my lords. Insofar as, my lords, what is the status of someone who joins the lower judiciary service? Lordship may just note, my lords, Rule 49, my lords, it says that no one shall be a full-time employee of a government and cease to practice as long as he is in such employment. So, my lords, by virtue of that, anyone who joins the lower judiciary, my lords, ceases to be an advocate in terms of the Bar Council of India rules. And this has been noted, my lords, in Deepak Agarwal. Lordship may just note para 83-84, page 741. Deepak Agarwal, my lords, actually goes into this aspect as to someone who's actually, my lords, a government servant or someone who's a pleader or a prosecutor. And what is the implication? Para 83-84, my lords, 83 and 84, page 741, volume Roman numeral V.2.
Yes.
And, my lords, the last submission is when the, my lords, 233 only says lawyer, my lords. By implication, my lords, everyone is, my lords,
Thank you. Thank you.
grateful, my lords, for the opportunity.
I am for the.
But I appear in Lord item 1501.26, Lord. I also appear for the High Court of Delhi. So Lord, we have segregated a time 10 minutes to each, Lord, to make our submission, Lord, good, Lord. Lord, stage pay, Lord, may I invite my Lord's kind attention to the Public Service Commission clauses which have been referred in the volume 2. And this is, my Lord, page number 80 for a moment.
Public Service Commission?
Plus 1920, just to make the submission as to how the lawyers are being considered for the purpose of direct recruitment. If not, just allow me to refer. This is page 80 from the volume 2, volume 4A and volume 4R. Well, this is after the Government of India Act 1915. And I'll just make a reference to section 254 thereafter, Lord. It just let me affirm, Lord, page 80 for a moment. From volume 4A and R.
4A?
Yes, no, this called as volume 4A and R, volume 4R. Roman, sorry.
On that, Lord, the
Document.
yes, the 1915 Act, that volume.
Yes.
Very good.
Well, I've tried to read the entire document on this. This is December 1920 document with respect to the appointment of the district judge.
Yes, page?
No, this is running page 80, Lord. And para 2 therein, Lord. Lord has that? Page 80, Lord. Para 2 therein, Lord.
Government of India resolution.
You know, this Public Service Commission's rules, Lord, that is what they term is this document. As this is a resolution passed by the Government of India as it then was, Lord.
Page 77.
Page, yes, Lord, it starts from page 77, Lord.
Government of India resolution.
Yes, my Lord. If my Lord is there, my Lord, can I bother, my Lord, with the last part on that page only just to read 2 lines, so therefore I can make my reference. There, my Lord, would find out just before the open competitive exams in examination London, there is a method of recruitment which is given.
How can we go to the 1920
No,
rules
no.
for interpreting the constitutional provision?
Not for that purpose. No, just allow me for 4 or 5 minutes. Lord, I am having 10 minutes time. Only I'll take 3 minutes for this purpose. Lord, try to make my submission now. What I'm trying to say before reading it, I can point out. At that point of time when 1915 Act was there, Section 254 was standing. Section 254 more or less talks can be seen in Article 233. Please clause
254 is not in 1915 Act, it is in 1935 Act.
I'm so sorry. 1935. I'm so sorry.
And
Yes.
1935 Act can't relate back to 1920 rule.
So that can be seen from this rule. Why I'm saying so, this resolution. At that juncture, the Government of India, as it then was considering whether there can be a direct recruitment from the bar. So the Government of India, through this resolution, has come to the conclusion, page 80, saying this, there has to be 25% direct recruitment as experimental basis from the bar. This is how it followed. When it followed up to 254, I would say enactment of Section 254, as it then was, all the Indian civil services were also carrying the judicial services node. So the judicial services were within the Indian civil services. So the subclause 2 of Section 254 says, anyone who is in the service of the Majesty will not be considered, but should be a lawyer either in the Scotland or the England for 5 years in practice. This is what exactly it has been borrowed in Article 233 as subject to my understanding. Why I'm saying so, my Lord, there is a reason behind it, subject to my Lord's kind appreciation. My Lord has already had I would say, all the learned senior councils, my Lord. What I'm trying to say, it is with respect to Article 234, which is the subordinate judicial services. There is the Public Service Commission. There is the rules which are to be incorporated. And for that purpose, there is a direct recruitment, not so direct recruitment, it's through the competitive exam. Likewise, when it was to be done in London. So far as Article 233 is concerned, what I'm trying to say, my Lord, as has been also argued by Sardar sir, that for the Honorable Supreme Court, for the Honorable High Court, likewise for the District Court, the legislative intent was to get the direct recruitment through the lawyers, or clause 1 is there for the purpose of promotion, and the posting I can ignore it for the purpose of promotion. This is what exactly, in my respective submission, is borrowed from there. My Lord, I borrow one of the observations of Honorable Justice Chandran. And I also follow the same with respect to Chandra Mohan, my lord. My side may say that I'm arguing from the other side. But what I'm trying to say, when Chandra Mohan was being considered, in the Chandra Mohan judgment, the Honorable Supreme Court has considered, and a particular line has been used. At that particular time of our country, as my lord, Honorable Justice, Chief Justice has referred, that law cannot be static. I also follow the same. That at that point of time, the magistracy was not only disposing taking the judicial action, it was also considered revenue action, the other administrative action. This is what exactly has been used in the Chandra Mohan. So this honorable court in Chandra Mohan was of the view they should be excluded. Therefore, only the judicial service has been incorporated for this very purpose. If we go by this interpretation as has now been projected by the petitioner's side, Lord, if we simply go by the same for a moment, take it like that I'm arguing from the other side, Lord, but just subject to the convenience and the balance and the equity and also Article 14. What I'm trying to argue on this, Lord, then in that case, Lord, from the first All India judges cases, which is based upon the Honorable Justice Saity's Commission, Lord, going up to the fifth judgment of this Honorable Court, Lord, that is not required then. Simply, Sita, because that Justice Saity's Commission report is based upon this very, I would say, principle that there is a direct recruitment from the bar and there is a promotion, there is a LDC, and for that purpose, there can be other avenues.
For experimental basis by increasing the number of.
Yes, I follow, Lord. This is what exactly I'm saying.
How did we hear it?
Lord, what I'm saying, Lord, if Lord may allow me, Lord,
Yes.
just I think 2-3 minutes left, Lord, just for this very purpose. What I'm trying to argue, Lord, on this as well. In that sense, my lord, if this honorable court come to the conclusion that judicial service should not be excluded from Article 233(2) for the purpose of interpretation of Article 233, I follow the suit for a moment. Then in that case, a new commission should be appointed. Then there should be a different research on this point, that whether there's how much promotion should be done, how much LDC should be done, and there should be direct recruitment.
Yes, thank you, thank you.
Just, my lord, two submission on the lighter note, my lord, just on that competency part, as my lord has pointed out. Honorable Justice Sandresh has also pointed out, only on that, my lord. If a judicial officer appears in the higher judiciary exam, for a moment, my lord, I'm so sorry, but please allow me. Just, my lord, I'll not take more than 1 minute. If a learned judicial officer, I use the term learned judicial, appear in the competitive exam with the lawyers who are also competing with him, being considered having vast knowledge and fails in that exam, whether his career, at least in the eyes of the common person, is not causing disruption, because that he is not able to pass the higher judicial exam, but after 2-3 years, let him be promoted, become a district judge. Lord, I'm just on the lighter note. But
Thank you.
This is not logic.
Thank
Lord, I'm just saying, Lord, and Lord, so far 35 years is concerned, Lord, as my Lord was observing. For the lawyer to compete in the to appear in the exam, the age is 35. Generally, the lawyer, the young student become a lawyer at the age 23, 24. So still 12 years is required. And so for the purpose of now with the honorable court decision, that 3 years as a pre-experience, then 7 years, it goes to 10 years, 11 years. So the age is almost equal. So it's I would say, fair play field for everyone. This is my response.
That you are arguing in.
My lord, I'm saying, Lord, for the lawyers, at least, my lord, let them also be on the fray. Let the best, I would say, merit may come on to decide the cases. There is no dispute to that, my lord. For that purpose, only the LDC was created, my lord, I would say. I'm so obliged.
Thank you. Next is on Mr. Azam.
My lords,
Gathering for
much has already been covered. I am representing in 501.15 and 0.26, my lords.
for whom?
For Rochak Bansal. Rochak Bansal
Who is Mr. Rochak?
he has filed a review petition and he is actually affected by Dheeraj Moore and he was a candidate in an examination in
You
Punjab.
should have been on this side then.
No, my lords. He is not the judicial officer. He is not the judicial officer. He is an advocate.
But how is he affected by Dheeraj Moore?
Because he was in the waiting list and an officer, a judicial officer got selected for the loan seat that was advertised and he was the loan.
We'll consider separately, yes.
Yes.
This will consider separately.
Individual matters will be considered.
A very short submission. Much has already been covered by Punjab and Haryana High Court's representation balance. What we are saying is in service actually bars the candidates who are judicial officers for the simple reason is that yes, they are covered under Article 235 for the insulation of the independent function as a judge performing their judicial duties. However, for the purposes of salary, remuneration and everything else, their funds are derived from the consolidated funds of the state and the union, and therefore that relationship of
Yes,
the
thank you,
master
thank
and servant remains with the state and the union, my lords. My lords.
Grateful. You are appealing for Bombay High Court.
My lords, yes. So that is item 501.12.
Yes.
Come to my written submissions, which are in volume 2, Roman 2, page 160 is the relevant page.
Now,
So, my lords, almost everyone.
since pointed out, what made you to take a different stand now?
Come to volume 7, page 656.
Better you don't say.
Volume 7, page 656.
Just because, see, Deepak, has come. So therefore you implemented it on the basis.
The registrar legal,
There is more.
the registrar legal who must have drafted this affidavit must have been from the direct recruit.
That's why, my lords, I was requesting.
We'll have to observe about your contradictory stand. So come to page 656.
My lords.
What is the stand taken by you before this taken? Volume 7.
There's no volume 7. No volume 7. It will be something else.
High Court, you should have faith. It's only you who have to have more faith in your officers who are working under you, not voting for the lawyers. Just to defend the rule. You can simply say, all right, we followed the law at the relevant point of time by the High Court to frame the rules.
It's volume 4, sorry, volume 4.
My lords, yes, my lords, I'm looking at volume 4 only.
Volume 4, page 653. Para 11.52.
My lords.
That would equally apply to Nitesh Gupta.
That's true. Yeah.
Yes, anyway, what are your arguments now? Tell us.
My lords, I've seen this, my lords. I've seen this, my lords. So that is why, my lords, I was requesting.
At that time, the registrar legal who must have drafted the affidavit must be from the promoting category, and now the registrar legal who has drafted this affidavit must be directly appointed.
Rather, may I say, my lords, maybe the mode of recruitment
Yes,
also
they are
has
anxious
changed
to
perception.
preserve the rule and status quo. Very well.
That's why, my lords, may that be also reason for change in perception. May I just request your lordship's attention to page 160, volume 2. I won't take much time, my lords. Page 160, volume 2.
Of your written submission.
Of my written submissions, my lords.
Yes.
As well as everybody else has also, all my learned colleagues and senior colleagues have brought your lordship's attention to the article 233. Page 160, it starts at 157. But may I request your lordship's attention to page 160. And was only one expression which I would like to beseech your lordships to is in clause 2 of article 233. My lords, the Honorable Chief Justice has, my lords, page 160.
Yes. If we have.
My lords, yes. My lords, may I just read this? Clause 2. A person not already in the service of union or of the state shall only be eligible to be appointed a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by the High Court for appointment. Now, my lords, my emphasis would be on the expression only, which appears in the second line of this clause. But what fell from your lordships time and again is whether the language of article 233 or clause 2 is restrictive. So our submission there is that the language is restrictive since it employs the expression only. Now with this background, may I request your lordship's attention to page 167 of this very note, where we have tried to explain, that is paragraph number 21. May I read paragraph 21, page 167. The distinction between these two sources has been emphasized by the Constitution bench in Chandramohan 1. The court held that Article 233(1) is intended to govern appointments of persons in judicial service, that is by way of promotion in consultation with the High Court. Article 233(2), on the other hand, specifically contemplates appointments from the bar and uses a restrictive word only. This expression excludes all other classes of...
Argued by everyone.
We'll consider.
My lords.
Anything you want to argue, you may submit.
Subject to correction, probably your lordship's attention to this clause expression only was not brought to
Yes.
my lords. Sorry. Then may I request your lordship's attention?
In Supreme Court, the lawyers are not present at all the time, so they don't know what is argued by the others.
That is too much for. Anyways, may I request your lordships to the another expression that the explanation that we have given in paragraph number 28, my lords.
Nobody, this is not the issue.
Because otherwise, my lords, yes. Para 28. Turning to the fourth question, it is necessary to examine whether a person who has partly served as a civil judge and partly practiced as an advocate for a combined period of 7 years can claim eligibility under Article 233(2). The plain text of Article 233(2) provides the answer. It uses the expression, a person not already in service of the union or the state shall only be eligible. Now, I'm pausing here for a moment to meander. The consequences of inclusion of those who are already in judicial service from the bar quota will have its own cascading effects, because a person who is already in bar is not permitted to compete or appear from the judicial services category.
How can that be?
Not yes.
We are arguing something which is totally unknown to the service jurisprudence.
No, certainly, no, my lords, therefore, no, my lords, therefore, my lords, in our humble submission,
What is this?
inclusion.
Sorry, it's an
May I just formulate? My lords, may I just formulate? My lords, may I just formulate? Permitting, my lords, suppose, my lords, tomorrow the officers of the judicial service are permitted to compete from the bar quota. My lords, it is not reverse applicable. There is no reverse osmosis applicable here. Then, my lords, in that case, it would also amount the reverse.
Are you arguing with seriousness?
Sorry, my lords, but then this is our stand specifically mentioned in paragraph number 22, 23 onwards.
Thank you.
My lords. So I raise my case, my lord.
Yes, Mr. Sindhu.
Please, minutes. I'm appearing in 501.11 minutes. I'm appearing for the High Court of Telangana. Minutes. My written submissions are at page 115 of volume 2 minutes. Much has been argued, my lords. I'll only bring to your lordship's attention 3 points, my lords, which have not been addressed before your lordships. The first point, my lords, is with respect to the principle of constitutional silence, my lords. So it's a given fact, my lords, that in any written constitution, there are certain silences which are on purpose left there, my lords, certain deliberate omissions. This is, my lords, the submission is with respect to question number 4 before your lordships today, where the explanation is specifically given in 124 and 217, and under 233, the constitution framers left that silence, my lords. That is not to be filled up before your lordship. Before your lordships may kindly have, my lords, one judgment, Manoj Nerula, my lords, which is, my lords, at page volume 5.3, my lords, page 778.
Volume?
5.3, my lords.
Page?
The judgment starts, my lords, at page 778. The relevant portion that I would like to point out to your lordships is at page 829, my lords. Paragraph 54 to 56, my lords, of this judgment. It's a constitution bench judgment, my lords. This judgment, my lords, was in respect of disqualifications regarding to MPs and MLAs, while looking into a constitutional silence with respect to another disqualification which was sought to be added. This honorable court, by way of a constitution bench, held that that silence would not be filled up, my lords.
Page 7.
Page 829, my lords. The judgment starts, my lords, at page 778. relevant portion, my lords, at page 829. May I read, my lords? Para 54. The next principle, lordships have it.
Yes.
The next principle that can be thought of is constitutional silence or silence of the constitution or constitutional abeyance. The said principle is a progressive one and is applied as a recognized advanced institutional practice. It has been recognized by the court to fill up gaps in respect of certain areas in the interest of justice and larger public interest. Liberalization of the concept of locus standi for the purpose of development of public interest litigation to establish rights of the haves-nots and to prevent damages and protect the environment is one such feature. Then, my lords, lordship may have para 55, my lords. In this context, it is profitable to refer to the authority in Bhanumati versus state of Uttar Pradesh, my lords, wherein this court was dealing with the constitutional validity of the UP Panchayat Laws Amendment Act 2007. One of the grounds for challenge was that there was no concept of no confidence motion in the detailed constitutional provision under Part 9 of the Constitution. Therefore, incorporation of the said provision in the statute militates against the principles of Panchayat Raj. In that, my lords, in the judgment of Bhanumati, which has now been recognized by the Constitution bench, my lords, the next page, my lords, at page 830. Bhanumati is quoted, my lords, para 49 and 50. If I may read, my lords. Apart from the aforesaid reasons, the arguments by the appellants cannot be accepted in view of a well-known constitutional doctrine, namely the constitutional doctrine of silence. Michael Foley, in his treatise on the silence of constitutions, has argued that a constitution abeyances are valuable, therefore, not in spite of their obscurity, but because of it. They are significant for the attitudes and approaches to the constitution that they evoke, rather than the content or substance of their strictures. The learned author elaborated this concept further by saying, despite the absence of any documentary or material form, these abeyances are real and are an integral part of any constitution. What remains unwritten and indeterminate can be just as much responsible for the operational character and restraining quality of a constitutional as its more tangible and codified components. Going further, my lords, at para 56, which is the most important part of this judgment, my lords, the question that is to be posed here is whether taking recourse to this doctrine for the purpose of advancing constitutional culture, can a court read a disqualification to the already expressed disqualifications provided under the Constitution and the 51 Act? The answer has to be in the inevitable negative, for there are express provisions stating disqualifications, and second, it would tantamount to crossing the boundaries of judicial review. In the present case before your lordships, my lords, specifically, the explanations under 124 and 217 have not been consciously and deliberately not been included within 233 minutes. In fact, my lords, the learned senior for the petitioners, my lords, has argued that the explanation under 217 does not refer to advocacy experience before holding a judicial office, but only refers to the one after, so it would not. But that, in fact, would inure to my benefit, my lords. Even under 217, any advocacy practice before holding of judicial office is not being counted. So any clubbing to that respect, my lord, in my respectful submission, ought not to be taken. The second point, my lords, that I would like to make is with respect to, my lords, the necessity for the direct recruitment and a quota. As lordships have already seen, right from 1920, there has been a quota, which has been 1/4 for bar members. That, my lords, in fact, has also been specifically noted by the Law Commission report, my lords, in, if your lordship may have, volume 4R, my lords. The Law Commission report specifically says that direct recruitment from the bar is necessary to infuse fresh and young blood, my lords. So this one point, my lords. One alternative submission, my lords, which I would like to place before your lordships, is that even, I'll take it against myself, my lords, that even if your lordships are to hold that 233 does not today prevent in-service candidates from being eligible for direct recruitment, the language of 233(2) is very clear, my lords, that the experience of 7 years of advocacy is not applicable for in-service candidates. Any eligibility which now has to be formulated, my lords, can only be prospective. Any such eligibility, my lords, cannot be in a retrospective manner read into 233. Right. These are my submissions. I'm extremely grateful for the opportunity.
Sir,
Yes, Manoj, I am appearing for the State Bar Council of Madhya Pradesh, my lord. That is IA intervention number 24074.
So I appear for Allahabad High Court, my lords.
So who is Mr. Yashovardhan?
Yes, Sam. Because I appear for Allahabad High Court, I adopt the submissions of Mr. Veej Gupta, my lords, squarely, because that covers, my lords, entirely our cases. Sir.
Very good, very good.
Okay.
Yeah, appreciate your action.
In fact, it's complicated, my lords, Mr. Veej Gupta to utilize my time.
My lords, I am for the intervener appellant, intervener, my lords, State Bar Council, Madhya Pradesh. This is IA number 240746 of 2025, my lords. We had helped to trace out the copy. My lords, I have prepared short written submissions also. My lords, may I just pass on, my lord, along with, so that's it. My lords, first, my lords asked a query in the morning, my lords. I apologize, I was not here. I was on legs before another court, my lords. My lords asked a question about what happens if any person, any advocate is selected as the judicial officer. Lords, and what's the practice in Madhya Pradesh or state bar councils across?
So what is the provision in the law?
Yes, my lords. So there are,
practice. It's
yes,
not a
my lords.
question of
In my intervention, my lords, I have filed the Bar Council of India rules, my lords. The Bar Council of India rules, my lords, please come to them, rules 43 and 49. I'll just read them. But before that, I'll point out 43 requires, my lords, that immediately I take up any profession, calling, vocation, my lords, which is inconsistent with my practice. I have to intimate by way of a written application to the Bar Council, the State Bar Council, on the basis of which, in view of 49, my lords, and read with section 35(4), I'll read that. It stands suspended, my lords. The license stands suspended. So that takes me, my lords, to the provision. My lords, may please come to page.
Documents are not part of the convenience compilation.
Yes, my lord. We filed on Saturday, my lords.
We will have to just wander from here to there. Could have been.
No, IA is not part of compilation, but part of record, my lords. We helped in tracing out yesterday, my lords. We gave.
Should have given whatever documents you wanted to, so that they could have been a part of compilation.
Yes, my lords, I received the instructions on last Thursday, Friday, my lords, by which time the compilation.
Why should we hear you?
Was,
we are not diligent enough.
My lords, I apologize. It came to me, and within 48 hours.
We don't know when it came to you or not come to you. Why should we inconvenience ourselves?
What's this?
As it is with so many voluminous documents.
The intervention application we helped in tracing out yesterday. We gave it.
Consider it should have been diligent if they wanted. The matter is pending since long.
So I'll just read out those provisions in the meanwhile, my lords, as they are searching, my lords. I'll just read out, because at least the position of law may be clear. My lords, these are BCI rules. Rule 43 says, an advocate who has been convicted of an offence mentioned under 24A of the Advocates Act, or has been declared insolvent, or has taken full-time service or part-time service, or engages in business or any vocation inconsistent with his practicing as an advocate, or has incurred any disqualification mentioned in the Advocates Act or the rules made thereunder, shall send a declaration to that effect to the respective State Bar Council in which the advocate is enrolled within 90 days from the date of disqualification. If the advocate does not file the said declaration or fails to show sufficient cause for not filing such declaration, provided the committee constituted by the State Bar Council may pass order suspending the right. This is Rule 43, which makes it mandatory for any person departing from the profession in any manner, digressing for any reason, any other profession, to intimate, my lords. And then, my lords, Rule 49, which was read out by my learned senior few in the first half. Rule 49 says, an advocate shall not be a full-time salaried employee of any person, government, firm, corporation or concern, so long as he continues to practice, and shall, on taking up any such employment, intimate the fact to the Bar Council on whose roll his name appears, and shall thereupon cease to practice as an advocate so long as he continues in such employment. That then there was a resolution which was adopted in 2001, which said, resolution number 156 quoted in this only. The IA is before, my lords. I'm reading page 86 of the IA. Rule 43, which I read out, my lords, is at page 81. Page 81, which I read out. And 49 is at page 86.
Which rule?
43.
43.
43, initially I read out at page 81 of the BCI rules. This is downloaded from the official website. Purportedly, and to my understanding, must be an updated document. It 86. 86, which fell for consideration in the judgment of Sushma Suri and Deepak Agrawal, which were referred to by my learned senior, my lords, is 49, Rule 49.
Oh.
So essentially, my lords, Rule 43 perhaps were not looked into in Deepak Agrawal, which casts a duty obligation mandatorily on the lawyer concerned himself to intimate within 90 days. So my instructions are, my lords, that a person, when he takes up the post of judicial officer, it gets suspended till the duration he serves on the post. And if he resumes practice, say after retirement, like district judges choose to practice in the High Court, before the High Court, after retirement, my lords, then it gets resumed.
If you intimate, only restriction from practice, not even suspension.
The suspension is punitive.
That's
Yes.
what.
If it is not
So
intimated.
in the rules, you can't practice.
We can't practice, but section 35 of the Advocates Act, 35(4), which we have quoted in the intervention, my lords, may just see in the intervention we have quoted. Where an advocate is suspended from practice under clause C of subsection 3, he shall during the period of suspension be debarred from practicing any court or before any authority or person in India. So though word suspension is used, so if the person intimates under Rule 43 read with 49, then under the rigors of 35(4) as interpreted in Deepak Agrawal and Sushma Suri, he is debarred from practicing. That's the necessary obvious outcome. Then I just 4-5 points, Malad. Quickly in 5 minutes, I'll sum up, Malad. Chandramohan has been read again and again. One thing which I would like to read, my lords, is Article 236, Clause B, which is the definition of judicial service. It says the expression judicial service means a service. 236B, the definition of judicial service, which Chandramohan said, my lords, that service in the context of 233 means and only means judicial service. Chandramohan said so. My learned senior read out those observations. I'll not read that. I'll just read the definition of judicial service under 236B. It says the expression judicial service means a service consisting exclusively of persons. That's the word used in the Constitution, exclusively.
Yes.
Exclusively of persons intended to fill the post of district judge and other civil judicial posts inferior to the post of district judge. So, my lords, if we read this definition in the context of the observation in Chandramohan, which said the service, the word service under 233(2) means the judicial service as defined under 236B, it would mean only and only judicial officers, which were obviously were meant to be treated out of stream of 233(2) is my second submission. The third submission is, my lords, that AIJA, my lords, 2002, All India Judges Association 2002, Vide Para 27, that has also been read out, my lords. Vide Para 27 records that prior to 2002, when Shetty Commission reports were coming in, there were essentially 50-50 quota. 50-50 quota means between 50% for the promotion, 50% for the direct recruits, because these are the only two available channels. So Vide para 28, AIJ case says to incentivize and to bring more innovative and young blood in the subordinate judicial services, we must have LDCE.
So where do you get from Shetty Commission that underage judicial officers that prior to that there was a 50-50 work?
Because that is said in the AIJ judgment. I'll just read that. AIJ judgment. That is said in the AIJ judgment of 2002. I'll read that observation, my lord. Para 27. Another question which falls for consideration is the method of recruitment to the posts of higher judicial service, district judges and ADJs. At the present moment, that is in 2002, there are two sources for recruitment to the higher judicial service, namely by promotion from amongst the members of subordinate judicial service and by direct recruitment. The subordinate judiciary is the foundation of edifice so and so.
Where do you get 50-50? You said that prior to that.
I'm sorry, not 50-50. They were varying. In some, I meant, my lords, only two sources. I'm sorry. In some states, Shetty Commission says, in some states.
It is sufficient that prior to that, there was 50% for promotees, 50% for directs. And for the first time by All India Judicial Association case,
LDC was introduced. LDC was introduced. Earlier, my lords, I stand corrected. I'm sorry. Earlier, my lords, it was some states at 30%, some states at 40%. The Shetty Commission says so. Some at 10%. So they said, the Shetty Commission said that to have a middle way out, the best possible percentage is to also cater to the concerns of seniority in the other stream. That is the promotees stream. We will have 25%. Now, my lords, in 2002, this 25% LDC was brought in for the very purpose which my lords have been observing for the last 2 days, to incentivize, to give a reason for young and talented blood to join the services. Para 27 it is observed, my lords. And the line says, furthermore, there should also be an incentive amongst the relatively junior and other officers to improve and to compete with each other so as to excel and get quicker promotion. This is what was said. So, my lord, the purpose of LDC, like my learned senior Mr. Shakdar said, the purpose of LDCE was precisely what is, my lords, for which we are interpreting 233 to mean that they must have chance in the direct bar quota. And then it was reduced in 2010 to 10% and then again to 25%. My lords, the point I am trying to drive home is that incentive already exists by way of LDC. Now, talking of the Madhya Pradesh rules, my lord, they are on record. A person can participate in the LDC examination, now 25%, after having 5 years of service as a civil judge senior division. So after 5 years, from junior division, he gets promoted to the civil services senior division. So within 10 years, he gets an opportunity in Madhya Pradesh rules, my lords. He gets an opportunity to participate in LDC. So that stream, my lords, mathematically, right at the age of 35, 36 is already available. It is already taken care of 25%. And my lord, that is not open for advocates. That stream is not open for advocates.
This one has already argued.
Yes. Next point, my lords, I'll come to Dheeraj more, my lords, especially the concurring judgment of Honorable Justice Bhatt. My lords, there is a purpose for which quotas were not existing originally under the Constitution, my lords. Like rightly, my learned senior argued yesterday, they never came down from the heaven. They were created in the AIJ case because there were disputes about seniority, availability of posts. Every year it was coming in. So quotas were introduced so that it is streamlined. Dheeraj More case, my lords, simply went by saying that there cannot be hopping from one stream to another. And the concurring opinion, Vide para 75 and 76, very loudly says so. What is the laudable purpose of this quota? The laudable purpose of this quota are that lawyers, when they join the services, lawyers are thought leaders. They have more dynamism than those coming from the other stream because they are in direct touch with the society.
Don't say that.
My lords, I'll read those observations. I'll read those observations. It is cast in stone in the judicial verdict.
We agree that Mr. Das Gupta has much more dynamism than all 5 of us.
I never intended to mean that.
To say that
the same logic will apply to our brothers also, the Justice Narasimha and Vishwanathan. So they,
Onwards,
they have obviously a more dynamic than that.
I am talking
That
about,
we acknowledge it as an individual, no problem.
this is,
Not
this
as a
is
principle.
just what is said in 75, 76, whilst explaining that lawyer quota must be kept sacrosanct and it should not allow be to mingle with the other, because LDC is already there.
Who's
That-
asking you to
yes.
mingle with it? You come with
Let's-
your own stream.
My lords, then next point is, my lords, I'm just quickly winding up, my lords. I'll take not more than 2-3 minutes. Kuldeep Nair judgment, my lords. Kuldeep Nair judgment, this is a constitution bench judgment, 2006-7 SCC. Look, this judgment I am quoting for the proposition that where the constitution has consciously used one expression, whereas it has omitted to use the same
Already
expression
been
in another place.
Already been argued.
Yes, Kuldeep Nair was in the context of secret ballot, voting by secret ballot. In case of president and vice president, secret ballot was allowed, but for council of states, it was not allowed. So the argument was made that secret ballot must be transplanted from that provision and be applied here also. In that context, Vide paras 420 to 425, there is an observation by the constitution bench of this honorable court that what is not expressed should not be inferred. That takes me, my lords, to one very important judgment which has been quoted again and again, Purnima, the judgment of Honorable Justice Bobde, my lords. It was quoted yesterday and today also. It has been quoted in the context of explanation to Article 217A and B. my lords. What was held is it uses the word, there are two streams even under Article 217. A is the stream for advocates, B is the stream for those coming from subordinate judiciary. So there is a place where this court, honorable court, observed that the purpose of adding explanation was to add clarity to the stream. Had explanation been not there, the streams would have moved independently. Why I'm referring to this observation from Purnima is, I'll quote the para also, is because such explanation is not there under 233. So even in light of Purnima, which is Honorable Justice Bobde's observation, my lords, clearly. Then, my lords, last point. Well, though this is not the subject matter of reference, but I must address this as a representing the State Bar Council, my lords. Well, there has been a perception, my lords. I was observing the proceedings. There is a perception, my lords, in the bench, my lords, across the country, that posts meant for direct quota do not get filled up. But, my lords, there are reasons far more to seek, my lords, to this. And there was a petition filed before the Madhya Pradesh High Court also. It was later on withdrawn. But the reasons are more than one. There are equal number of participants sitting, 5,600 persons sitting for 25, 26 vacancies, hardly one or two clear. So what is the reason that out of 5,000, 6,000, only 1 or 2 persons, candidates are competent? Lords, I have spelled out the reason in my intervention application that one of the primary reasons is that valuation, checking, invigilation of papers of these examination, direct bar quota, is being handed over to the in the hands of the other stream of 75%. I have quoted in my this, and there was a
Please don't argue. Yes, who is the next thing? Yes.
You don't understand how things happen.
Well, it's my colleague from Bar Council of Delhi will just argue.
No, sorry.
Lordship.
Thank you. Who is next? As per the list.
Sir, we are.
Your Lordships, I'm appearing for the Bar Council of Delhi in IA number 240131.
You are Mr.
Satyam.
Satyam Chand Surya.
Yes, sir. Chansurya, sir. His name. I'm.
Your Lord.
The next line is Mr. Satyam Chand Surya.
Sir. Your Lordship, by the way of this IA, which is mentioned in 240716 on volume 21.
Who are you?
I am representing a common lawyer who is practicing before District and Sessions Court Bhopal. And by this intervention, I want to show cause the grievances which a common lawyer feels who is practicing and his.
Sorry,
Sir.
You only address on the question.
Sir.
You only address on the interpretation of.
Yes, sir. Article 233(2) interpretation, erroneous interpretation, how affects me in the examination process.
We are only asking.
Yes, sir. I'm coming on this, sir. So, sir, my humble submission is this, that Article 233(2) permits only one interpretation, that a candidate have not only have served 7 years of continuous practice as an advocate up to the date of joining the post of district judge.
has been not for less than 7 years on advocate employs present perfect tense, signifying a state that began in the past and continues into the relevant present. The emphasis is sustained practice as an advocate, not past tenure clubbed with service. If Article 217 and 124 are involved to interpret Article 233 so as to permit the continuing of combined experience at the bar and in judicial service, then with respect a serious anomaly arises. No judicial officer who had been completed 7 years of practice at the bar prior to joining judicial services would thereafter remain eligible for appointment as district judge under Article 233(2). Experience and knowledge gained by a successful lawyer at the bar can never be considered too less important from any point of view. Vis-a-vis.
Nobody is denying you from appearing.
Sir, sir,
Only thing is whether you should compete with the others or not.
No, sir. Sir, our considered view is only this, that only this 25% quota, which allows us to join judicial services with a fresh view, with a fresh intent. So we are humbly request you that this is our humble submission that Article 233(2) specifically says that a person who is not previously in service.
Yes, thank you.
And sir,
That's already argued, yes.
Sir, only last submission, sir. Sir, our last submission is this, that our Madhya Pradesh Higher Judicial Services rules, 51C, sir, this is in our appendix. Please have a look, sir.
Tell us what is
Yes,
the
sir. 51C, after unfilling quota for 2 consecutive years, our quota is changed to judicial stream. Sir, is this allowed or is this permissible to convert any quota?
That is not a question before us. Go and challenge those rules before the High Court.
Sir,
Go and challenge those rules before the High Court.
sir, the concept of culpable legislation, which cannot be done directly, cannot be done indirectly. This is a hard.
Thank you.
Your Lordship.
Your Lordships,
The list is exhausted, yes.
Lordship.
Your Lordships, may I please,
501.3, if your Lordships permit only 1 point.
No, your name is not there, you should have.
It's not there.
Your Lordships,
5 minutes.
Lordships,
Lordship,
I appear for the Bar Council of Delhi in IA number 240131, Your Lordships. I will only take 2 minutes, Your Lordships. Your Lordships, my written submissions are on page 22 of volume 2. Your Lordships, I have 3 short submissions to make, and I will not bother Your Lordships with the case laws and the arguments that have already been made. Your Lordships, I urge, limb 1 of my argument is, Your Lordships, I urge Your Lordships to adopt the plain and textual interpretation of Article 233, Clause 2. And Your Lordships, we know that the primary rule of construction is that intention of the legislature must be found within the words used by the legislature itself. And Your Lordships, that has been clearly indicated in Jai Shri Lakshman Rao Patil. Your Lordships, I will only indicate the citation for reference.
Somebody already pointed out those paragraphs.
Yes, Your Lordships. So, Your Lordships, my humble submission is that what the learned counsels on the opposite side are advancing is a poetic unearthing of meaning and to read between lines that do not exist. Your Lordships, it involves...
Your motor.
No, Your Lordships.
Lordship.
Your Lordships, just 1 more minute, Your Lordships. Your Lordships, my learned counsels are asking us to impute an understanding or explanation that is not within the text of Article 233, Clause 2. So, Your Lordships, as my learned counsel argued that it would involve rendering the words not already in service of the union or of the state superfluous. Your Lordships, my humble submission is that the negative stipulation is an express constitutional bar against the in-service candidates, Your Lordships.
Thank you.
And Your Lordships, I will just summarize my argument, Your Lordships. Point 2 is that Your Lordships, eligibility has to be determined on the cutoff date. That is the date of application and appointment. Otherwise, it will lead to practical issues and problems for the recruit. And Your Lordships, just 1 more point on the purpose of the advocate representation.
Lordship, first.
Highly obliged, Your
May I,
Lordships.
Lordship, please.
Yes, 2 minutes, yes.
Okay.
Because of this answer here.
Please. Lordship, I have argued to the point, first see in the Bare Act, the language and the sentence, how it is structured in Article 233. There is appointments of the person to be, after that comma, and then end, the posting and the promotion of comma, then district judges, it is in the plural.
These are the two sentences. Here, the appointments include the persons already in the judicial service and the advocates for the direct appointment. It also includes the bar quota. Let me complete the chain of that. And second is the posting and promotion of. These are, it is only for the persons already in the judicial service. By virtue of clause 1, civil judge and advocates both can be directly appointed. And when we read clause 2, here is the language: a person not already in the service of the union or the state shall only be eligible to be appointed a district judge. Here, in language, only the word district judge, and in starting the word is only person. And in clause 1, there are the two things. First, they use the word appointments, then you use the word persons. And in when the end joining both the sentences, then you use word district judges. It is covering the three types of persons. The first, the person already in the judicial service, and also the advocate.
What is your argument?
Lordship, I am explaining to the point. Let me.
What is your submission? Just tell us what is your proposition.
My proposition is that under bar quota, the civil judges can be appointed. They can also apply in that. That is my submission. And for that,
that has been argued by, sufficiently argued by everyone.
Lordship, that is argued. Everyone is saying that nothing in the clause 1. We have to compare the clause 1 with the clause 2. It is the language of the British India used in this, because Lordship will clearly mention appointments of the person to be, then after comma, and the posting and promotions of, then comma. Posting and promotion can be the person who is already in the service, not.
Thank you, Mr. Sharma. Yes.
So, Lord,
Thank you.
Okay. Great.
Yes, Mr. Wood.
Three very quick points. My learned friend, Mr. Nidesh Gupta, referred to Bal Mukund, Constitution Bench judgment, and certain observations in that. Now, what your lordship will note, because I don't have time a lot to take your lordship to the relevant parts of Bal Mukund, but what your lordship will note when you read the whole judgment, there, my lord, there was a legislation which provided for a certain.
The question was whether the legislature, by the legislative enactment, could provide for a reservation in the post of district judges
and below,
and subordinate,
and even civil. Yeah, correct. And civil. Yes, yes.
The Bal Mukund held that the entire scheme would show that 231 to 235, that the control vested with the High Court, and unless there was a consultation with the High Court, the finality is given to the High Court, and the legislature could not have.
Correct, absolutely right. There is a complete code. It's a complete code, and therefore you cannot introduce into it conditions which don't exist in this complete code. That is 233 up to 237. And therefore, even by legislation, you can't do it, because this is a chapter of the Constitution which is a complete code about the subordinate judiciary.
And separation of.
And separation of powers. So those are the two bases.
Independence of judiciary.
Correct.
So this question did not.
This question as to whether members who are in service can sit for the direct recruitment of district judges never arose. So any observations, my lord, made are per incurium. They were never, my lord, argued. Obiter, because they were never argued. That was not the issue. So therefore, my lord, some observation made there is completely obiter. So
they say that Satyanarayan has been specifically approved by Bal Mukund. So therefore,
not at all, because that question never arose in that. So therefore, my lord, approving Satyanarayan is not. It may have been just cited by the way, but it is not, my lord, questioned or approved. So that's number one. Then, my lord, my learned friend said that in Rameshwar Dayal, the only ground on which those two people who were not advocates on that date and their licenses had been suspended were my lord, given the benefit was that they were also held to be advocates, but that is not correct. There was a second ground as well. In fact, that was the first ground. Lord, after noticing at page 110 of volume 5.1 that Article 233 is a self-contained provision as to a person who is already in the service of the Union, no special qualifications are laid down. Governor can appoint such person in consultation with the High Court. Then, my lord, 2 pages later, at 112, after, my lord, 111 bottom, they say, now we now turn to the other two respondents whose names were not factually in the rolls. What is their position? We consider that they also fulfill the requirements of Article 233 of the Constitution. Harbans Singh was in service of the state at the time of his appointment. And Mr. Vishwanath Shastri, appearing for him, has submitted that clause 2 of Article 233 did not apply. So this was accepted. It is not that this argument was rejected. They say, we consider that they also fulfilled the requirement of 233. Harbans Singh was in the service of the state at the time of his appointment, and Mr. Vishwanath Shastri, appearing for him, has submitted that clause 2 of Article 233 did not apply. We consider that even if we proceed, now this is the alternative. First ground is that he was in service, and therefore under 233, the governor could make appointment in consultation with the High Court. 112 top, my lord, if your lordship has that page.
Yes.
Absolutely clear in my humble submission, my lord, that the first ground given is that because they were in service, no other conditions applied, and therefore they could be appointed by the governor in consultation with the High Court. That is at 110, and this is at 112. We consider that they also fulfilled the requirements of Article 233. Harbans Singh was in service of the state at the time of his appointment, and Mr. Vishwanath Shastri, appearing for him, has submitted that clause 2 of Article 233 did not apply. Then we consider that even if we proceed on the footing that both these persons were recruited from the bar, so that's the alternative, Lord, finding. And my learned friend, Mr. Gupta, Lord, then read the next page. They did not cease to be. That's the alternative, my lord, finding. They did not cease to be. Of course, we'll succeed either way. But the point is, the first one makes it absolutely clear that if you are in service, then that condition of an advocate of 7 years does not apply to you. And that is why these two, my lord, on the first ground, they were held to be. Otherwise, there was no purpose of writing that. Harbans Singh was in service. So therefore, the first point, namely that because he was in service, therefore he is eligible, because there are two streams which are eligible. One is people in service. So therefore, my lord, it was not decided only on the next page, which Mr. Nidesh Gupta cited, my lord, page 113. There was some argument that they did not go into. That was based on section 4 of the Legal Practitioners Act, not, my lord, the argument about in service. So that is, my lord, number 2 after Bal Mukund. Then on stare decisis, my lord, there is a recent 9 judges judgment of this court in which there are two
Royalty.
That property,
Property or royalty?
my lord, on 31A. Lord, the judgment is a little long. I've just taken out that one. It's 600 pages. It's also only in SCC online. So your lordship doesn't have that book in the court. Para 106 and 107 and 108. 9 judges. And this would apply to us on all fours. Mr. Tushar Mehta, the learned Solicitor General of India, has argued that this court has consistently upheld the observations of Justice Krishna Iyer and Ranganatha Reddy, and this is not a case of jurisprudential inconsistency or conflicting decisions. The observations in Sanjeev Kok on Article 39B, adopting the minority view in Ranganath Reddy, have been followed in subsequent decisions of this court. These decisions include inter alia so-and-so, so-and-so, so-and-so. Thus, it was urged that this court should refrain from unsettling a position of law that has been consistent for several years and has acquired the status of stare decisis. We are not inclined to accept this submission. In Sita Soren, a constitution bench of this court, speaking through one of us, had occasion to clarify that the doctrine of stare decisis is not an inflexible rule of law. The court may review its earlier decisions if it believes that there is an error or the effect of the decision would harm the interests of the public, or if it is inconsistent with the legal philosophy of the Constitution. in cases involving the interpretation of the Constitution, this court would do so more readily than in other branches of law, because not rectifying a manifest error would be harmful to the public interest and the polity. The period of time over which the case has held the field is not of primary consequence. So this would squarely apply to us, quite apart from the fact that actually the law that has held the field is Rameshwar Dayal and Chandra Mohan. If it is wrongly interpreted by later judgments, you can't say, well, this is the law that has held the field. The law, the binding law, that is the 5 judges which has held the field, my lord, is Rameshwar Dayal and Chandra Mohan. So the question of saying, no, no, you don't disturb something which has wrongly interpreted the binding judgments of this court, Lord, the question doesn't arise. Then just one last thing, my lord, and that is on 233(1) verses 2, because 1 uses the word consultation and 2 uses the word recommendation. And there is something made by Mr. Nidesh Gupta on that. Now, my lord, frankly, 233(1) or 2 do not refer to either direct recruitment or promotion, in the sense that it's not as if 233(1).
Appointment from promotions, posting all.
Correct, correct. So therefore, his submission that 233(1) is promotion, 233(2) is direct recruitment does not follow from the constitution. Yes. So therefore, now, supposing it is held that insofar as lawyers are concerned, there has to be recommendation, because it refers to recommendation immediately after lawyers. Even if that is so, it doesn't make any great difference. If in the case of, my lord, civil judges, there is consultation with the High Court, and in the case of civil lawyers, there is recommendation. Today, that, my lord, distinction has more or less disappeared. There are 2 judgments, Lord, on 233.
That recommendation is required only at the initial stage. It may not be required.
Yeah, so therefore to say that because
Subsection is for appointment, see, this, though it also says appointment, subsection 2 deals with the requirement for a lawyer 7 years, or 7 years one thing, recommendation is another thing.
Correct, correct.
These two are required to.
Ultimately, there has to be consultation.
Yes,
recommendation is a subset of it, and that has kind of disappeared, my lord, because
part of eligibility criteria.
yes. So may I just read, my lord, if your lordship, I can just point out one paragraph, and that is, my lord, paragraphs 34, 35, and 36 of 1982 3 SCC 412. It's a 3 judges bench, MM Gupta, where, my lord, they have used the words consultation and recommendation interchangeably, that either way, and this was a case of promotion, and they said, look, you have to consult, but unless the High Court recommends, you can't even promote. So therefore, my lord, even in case of promotion, the High Court will have to recommend, and therefore now today, that distinction, if at all there was something meant at the original stage, my lord, today that distinction has disappeared. Today, ultimately, the Constitution doesn't spell out if there is any difference between consultation and recommendation. Ultimately, by and large, they mean the same thing. Now, my lord, just one last thing, which is that they were saying it should be prospective. But once your lordship lays down the law, my lord, that is what the law always has been. And therefore, of course, your lordship can save appointments which are already made with 100% lord reservation of quota for lawyers. That may not be affected. But people like us who have sat for the exam, cleared the exam, etc., they should not, my lord, lose the fruit of their labor. So therefore, once your lordship lays down that yes, they were eligible to sit for the exam, lord, if they have succeeded, they must.
Here, we'll be only deciding the questions that are framed.
No, they were saying that your lordship should say that this is only prospective. That is all I am saying. That should not be said. Yes.
Was to consider para 48 of the judgment, your lordships, wherein the honorable court, 3 judges have specifically said that those who were functioning during the interim orders, those interim orders stand vacated. So your lordships may have to say that if the advertisement or the rules provided for this criteria, your lordships, that benefit will have to be given to those people.
So we'll be answering the questions, and thereafter
Your lordships, para 48.
Come to the regular bench.
That will go, the petitions will go before the regular bench.
Indicate, I'm just.
You don't need it all now. What, these are fully consequences.
We are only in a reference. We will be deciding the reference.
Yes.
Answering the questions, we will not be deciding it. So,
While the matter.
what is the effect of the answers will all depend on when we are decided.
Submission and history of lordships will be, because that once Lordships decided that there was eligibility, there are rules, the advertisement provided for, then that.
We are not deciding the individual
Please
question.
refer argument for the appropriate bench.
Just one judgment.
No, no.
In stare decisis, just one
No,
judgment.
no, thank you, thank you.
Just. There is just.
Pandurai. What does it do?
Notes the fact that between 1953 and 1964, as part of the constitution, it notes that they were recruiting from both sources into.
Together.
Also, there is a distinction between being on the rolls and